case briefs, and so much more. LSData's got what you're looking for.
When the Johnsons sold their 3-year-old home to the Davis family, they assured the buyers that all known roof issues were resolved, a promise embedded in their sales contract that also included a provision for roof inspection and repairs. However, things were not as they seemed. After the Davises moved in, heavy rain exposed the underlying roof defects, causing significant water damage to their new home. Deceived and disillusioned, the Davises filed a lawsuit against the Johnsons, accusing them of fraudulent misrepresentation. They argued that the sellers, well aware of the existing roof issues, intentionally hid crucial information that would have influenced their purchasing decision. This charge was not taken lightly by the court, given that the law requires sellers to disclose any material facts not within a buyer's reasonable reach of observation or attention. The Third District Court of Appeals found the Johnsons guilty, ruling that they had conducted fraudulent concealment by not disclosing the unforeseen roof issues. The court ordered them to return the deposit with interest to the Davises and cover their legal fees. This decision was appealed to the state Supreme Court, maintaining the intrigue in an already compelling legal drama. In the Florida Supreme Court, the Johnsons' strategy to rely on the age-old doctrine of caveat emptor or buyer beware floundered. The Supreme Court approved the appeal court's decision, establishing a landmark precedent, Posner v. Davis. It reasserted the seller's duty to disclose material facts not readily observable and unknown to the buyer. The decisiveness of the ruling was marked by the fact that 3 of the 5 judges concurred fully, with 1 concurring in result only, and a lone dissenting voice offering a different perspective.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.